Okay, so welcome everyone to the Keeping Families Together Act and Fostering Information session. I'm really glad that you're here. Um, really quickly, I'm Holly Luna and I serve here at DCYF as the Caregiver Retention and Support Program Manager. And today, this information session is really for foster parents to learn more about the Keeping Families Together Act, otherwise known as House Bill 1227. Together, Jeannie, Renata, and I, who will introduce themselves in just a couple of minutes, we're going to be describing the changes that the Keeping Families Together Act makes and how foster families may see those changes play out. We also think that some of the information in the presentation may be helpful for other people in the child welfare community. And then I want to give you just kind of an idea of what you're going to hear about. So these are kind of some guide markers as we go through, so you have an idea of how long the PowerPoint is, and before we'll get to the question and answer period. Today, we're going to tell you more again about the Keeping Families Together Act. You're going to hear that phrase a lot today. And then we're going to discuss the changes it makes to removal standards and other considerations before moving on to kind of how the bill reinforces kinship placement priorities, and it creates space for courts to order initial licenses. Then we'll end with questions and answers. Throughout the presentation, you can use the question and answer feature to ask Jeannie and Renata and I questions. There is ample time for us to talk about the questions, so please rest assured about that. Also, we encourage you, if possible, not to ask your question multiple times in the question and answer box. The only reason for that is in our previous presentation today, we had about 50 questions and we wanted to make sure that we answered all of them. And it was a little hard to sort through. So if possible, ask your question once. And then also you're welcome to use chat to say hello to us, to ask one of us a question. Finally, the other thing that we want you to know is that if you are a foster family, you can also contact us after this to get training credit for attending today. Finally, one more thing, there may be a few questions that might get out of scope. If so, we'll still do our best to answer them, but please don't feel, we hope that you wouldn't feel angry or overly frustrated if we're not able to get to your question today. So we want to reassure you that questions shared with us during today's information session will also be used to develop an FAQ, a frequently asked questions document, that will also be posted on our website. Along with that will be this recording and a copy of the PowerPoint. So with that, I'm going to jump into the meat of this. We've been talking about questions. So we know that foster parents have a lot of questions right now about what are the potential impacts of the Keeping Families Together Act. And we want to address a couple of them and highlight for you some of the things we'll be talking about. So really quickly, some of the questions that we've already heard are, do you still need foster parents? And the answer is a resounding yes, everyone. In our previous presentation today, I asked Jeannie and Renata just to help me reiterate this, and we will talk about it more. But Jeannie and Renata, can you quickly introduce yourself and just reiterate for us one more time? We still need foster parents.
Hi, everybody. I'm Jeannie Delaplane, and I'm the Kinship Care and Guardianship Program Manager for Headquarters statewide. And absolutely, I don't know what we'll do without foster parents. So you guys better not go anywhere.
Hi, I'm Renata Watson. I'm with the licensing division, and foster parents, I think, are one of our most valuable resources. I worked at the placement desk for a time, and I can tell you that we don't have enough foster parents. We love you, we value you, we need you, and we appreciate you.
Yes. Thank you so much, Jeannie and Renata. Okay, so everyone, we still need foster parents. We're going to talk about that more. Here's the next question we've heard a lot. Are foster parents only going to get our, quote, hardest kids? The answer again, everyone, is no. Foster parents don't have to do guardianships, and foster parents will still be able to adopt. So I want you to know we're going to talk about those questions more, but we're also going to jump into a little bit of the meat of our presentation. Again, there will be ample time for questions and answers. So if you're worried, it looks like one of our participants already asked a great question in the chat. Keep them coming. With that, let's talk a little bit just about what was House Bill 1227. House Bill 1227 was a bill that was approved by the 2021 Washington State Legislature. So they approved the bill. It was also known and introduced as the Keeping Families Together Act. And today you're going to hear us use that language because we believe that the basis of the legislation and the goals of the legislation are the direction that we want to move in. And we think that the title of the bill really helps us understand its goal and intent. So this bill, the parts of the bill, will go into effect on July 1st, 2023. Those are the parts that we're going to talk about today. Really the basis of the legislation though, and as you see on your screen, is the belief that when children and families are better served by their loved ones in their community. So when we can stay in our communities of origin, when we can stay with our families, we believe, and there's research that indicates that children and families have better outcomes. Additionally, and we'll talk about this one later too, the goal of the legislation is really to help us, us being DCYF, continue to reduce the number of children in care and to reduce racial bias and disproportionality. So for those who may not be familiar, racial bias shows up in our system, and we see disproportionality. If you're not familiar with that term, it means that the proportion of children who are in foster care, I'm using placement in foster care as an example, the number of children who are in foster care, the percentage of those children who are, for example, Black or Brown, exceeds the number of Black and Brown kids in our general population. So they're overrepresented or disproportionately represented in foster care. With that, these are some of the things I said we were going to talk about today. So let's jump in. We're going to talk about how the Keeping Families Together Act changes removal standards and considerations. Also, how it helps us continue to refocus and reinforce our kinship placement priorities. And it creates this pathway for courts to order initial licenses for our kinship caregivers. I'm going to go ahead and ask my colleague Jeannie to kind of start talking more about those removal standards and considerations.
Well, I already see folks beginning to ask questions about this in the chat. And so what I would say to you is keep your questions coming. And help we get like, well, that tilted. But keep your questions coming. We're gonna get through the PowerPoint and we're gonna circle back and have plenty of time for Q&A. So let's first talk about how 1227, and I like to start with this. I really want to emphasize 1227 is about shelter care. This is about our time period at shelter care. So our removal standards and considerations have changed based on 1227. And what is really, it's interesting because in some ways this is a change, in some ways it isn't. We have always been required to explain how, you know, the conditions at the home and the child being safe go hand in hand. We have to be able to show the causal. I think what's new is the factoring in of harm of removal. So is it better to leave a child or does it create more harm to remove a child? And that's really a crux of a lot of this information. So we have to explain how imminent physical harm outweighs the harm of removal. And also if we've offered any prevention services to the family that might prevent or eliminate the need for having to remove the child. So go ahead, next slide. So this slide is about a lot of language. And I'm going to just say to you, the current RCW language, a lot of it remains the same. what has been added is the imminent physical harm, and it's due to a child abuse or neglect, including that results from sexual abuse, sexual exploitation, or a pattern of severe neglect. So go ahead and I think it's easier to talk about this in the context of examples. At least that I learn better from examples. So let's, example number one, the parents are actively using drugs. So causal relationship, no causal relationship. Causal relationship would be drug paraphernalia is observed in the home, and there's a 2-year-old, and the 2-year-old is toddling around, can reach the drug paraphernalia. You can clearly make a line between that causal relationship between the drug paraphernalia that's being observed and the 2-year-old not being supervised and possibly being harmed because of the drugs. Another example, though, of no causal relationship. Drug paraphernalia is observed in the home, but the 2-year-old's needs are being taken care of. The 2-year-old can't access the drugs. The parents are putting the drugs away and, in a lockbox, only using when a child is not present. It's difficult to make the causal relationship between imminent physical harm and the drug paraphernalia. Okay, next slide. Another example is parents having physical altercations in the home. So sometimes this happens, physical altercations in the home, also domestic violence, right? So an example of a way to link the two would be physical altercations are occurring in the home, and the child steps in and tries to protect one of the parents and is placed in immediate danger. That's an example of causal relationship. But parents having physical altercations in the home, but the child's not present, there is no causal relationship there. Or let's say the child was home, but maybe in the next room over playing, I don't know, playing Game Boy or something. So there would be no causal relationship there either. So the bar, I think what I'm trying to say to you is, I don't know that the bars have changed all that much. The only thing that's changing is that we have to be able to articulate the relationship between what we're observing and imminent physical harm, and if the harm outweighs the removal. Okay, Holly, I think the next slide goes to Renata.
Okay, so the next thing that 1227 does is it really looks at when will children be placed with a foster family at a shelter care hearing. And ultimately, the judge is going to ask if the parent or child has a preferred caregiver, or are there any relatives or suitable people? So these are like friends of the family, coaches, teachers, best friends, parents, who are available, who can both protect the child from imminent physical harm and support efforts to reunite the child with their parents. If there are no identified preferred caregivers and there are no relatives and no suitable people, the judge will also be asking us to answer some questions about placement in a foster home. We must be showing that the foster home is the least restrictive setting for the child. We have to show that that foster home can meet the child or youth's special needs. We need to share whether or not the child or youth can be placed with their siblings. And we will share the city that the foster family lives in and indicate how that limitation won't limit the family time for visitation. Additionally, we'll be talking about if the child or youth can stay in the same school. The reason why we're addressing all of those topics are because when we look at harm of removal, separation from siblings, limitation to family visits, and leaving a school are all things that are detrimental and harmful to children. Next slide. There are some changes to kinship placements as well. In the past, DCYF may have written off appropriate caregivers, relatives, or suitable others for reasons like maybe they weren't sure if they wanted to be an adoptive resource. And because of the permanency from day one push, workers may have chosen to place in a foster home that was an adoptive placement over a relative that wasn't sure if they wanted to be a permanent placement. Jeannie?
Hmm.
Oh, okay. We also may have written off a relative who didn't think that the relative parent did what they were accused of. And in the past, we may have said, you know, if you don't think that the parent did what we said they did, we're not going to trust you with the child. And we can't do that. We have to look at that person and say, not do you believe they did this or not, but will you follow the court order and make sure that there's no unsupervised contact, or follow the court order about supervision. And additionally, some other reasons why we may have written off caregivers in the past is we didn't think that they could pass a licensed foster home study. And we can't take that into account. If they are able to pass a background check, they're willing, they have a relationship with the child, and they are willing to take in that child and meet that child's needs, they're willing to allow visitation and follow the case plan, we need to place with these caregivers that in the past we may have written off. 1227 also authorizes or tells the courts to order the department to look at issuing an initial license for kinship caregivers. And I'm using kinship to cover both those relatives and those suitable other persons. So I'm sure you may have also heard about like a child specific or a kinship license. So I'm just going to explain sort of the difference between the similarities and difference between the two. So both of them are specific to a particular child or children. Only relatives or suitable others, the kinship caregivers, are eligible for them. And then those families, when they receive those licenses, are placed on voluntary no referrals. They can't take in any additional children. It's just for those children. So the initial license, which is court ordered, is currently only available at that shelter care hearing. The court would order it. The family has to pass very minimal requirements, and that license would be issued for a total of 90 days. And that 90 days provides a foster care reimbursement to those caregivers for basically 3 months while they work on the licensing process. For you general foster parents, you may have taken months or years to come to this decision that you wanted to open your homes to children. You had time to prepare a bedroom and maybe put away savings. These kinship caregivers are having children dropped off at 1 o'clock in the morning and clearly have not prepared their homes for licensure. However, it was important to be able to reimburse them for caring for children anyway, while they work towards that licensing process. The kinship license is very similar, or the child-specific license is very similar to a general foster care license. They meet the same WACs. It's the same WAC book. However, we do allow some non-safety waivers for relatives that we would not waive for a general foster parent. So an example that I gave at the last one was maybe immunizations. So if you're a foster family who have, many children coming, the potential for many children in and out of your home, we want to make sure that the household members are vaccinated and that the children are safe that are coming and leaving. If you're placing a child with a grandma where they were already spending every weekend, looking at her immunizations just doesn't have the same impact for general children in care. So And the kinship license, similar to a general foster care license, is a maximum of 3 years, but it is renewable.
So let's talk about this for a second. And I'm not trying to say this. So I think sometimes there are 3 things that are going on, and really 4 things going on that really all play in together. First and foremost, DCYF is becoming a kin first agency. So what does that mean? You know, what does kin first mean? Because I think you're going to hear that a lot in the future. And what it means is, as an agency, we're really dedicated to looking for family connections for kids if they have to come into care. And the reason, the why behind it is that the research has shown that placing a child within their own family reduces the trauma of removal from the child's home. And we know that kids who are with kinship caregivers are less likely to have placement disruptions. They do well. And so the other thing is when we are able to keep kids within the relatives or with a suitable person, it also keeps them connected to their culture, their community, their friends, their families. And so these are why all of a sudden you see a lot of new things coming down the pipe. So here are 3 examples of legislations and decisions that have happened in the last year. So House Bill 1227, House Bill 1747, and the KW settlement. So House Bill 1227 is what we're talking about today. Again, I want to emphasize over and over and over, House Bill 1227 is at shelter care. It's not throughout the life of the case, it is at shelter care. It emphasizes placement with kinship caregivers. So for our purposes, when we talk about kinship, that means relatives as defined in RCW and suitable persons also defined in RCW. It also introduced what Renata was sharing with you a little while ago about the initial licenses. So then what is House Bill 1747? Well, it went into effect last June. And there were a couple of things that came out of 1747. First and foremost, it emphasized that the priority for placement is relatives throughout the life of a case. So this is not new. And this was something that was brought up in our last session, and I want to reiterate it. Relatives being the priority for placement is not new. That has always been in policy. It's also a federal standard. Also, 1747 talked about how gave us a bar where before filing for termination of parental rights or moving forward with adoption, we are required to talk to both the placement and the parents about guardianship as an alternative to adoption. Now, does that mean we're never, ever doing adoption again? No, it means we have to talk about it and we have to seriously consider why guardianship is not a viable plan. Now, there will be cases where adoption is the right choice, and we'll achieve that once we go through our shared planning process and have a lot of discussions. And then the other thing that was also contributing to our kin first culture is the KW settlement. And it says we must give meaningful preference to relatives, relative placements, that the courts have to treat relatives as preferred placements. We cannot prioritize future permanency over current stability and well-being. So what does that mean? We can't prioritize future permanency over current stability. It means that when a child is placed in a home, we have to consider what would it be to remove that child from their current stable family and move in with somebody else who might be able to offer permanency. Is one better than the other? And the settlement is saying permanency does not trump stability. And then we cannot place children who are dependent in unlicensed care with unrelated families who only have an approved home study for the purpose of adoption. That also came out of KW settlement. So all of these combined together is how we arrive at an increased focus and an emphasis on kinship placement. Next slide. Oh, this is you, Holly.
Well, hello, everyone, again. So folks, one, thank you for all of the questions. We see those coming in. At this time, just to respect the privacy of folks who want to ask questions or may want to, if we're kind of getting into the weeds on some different things, I'm going to stop the recording here. Okay.